Good morning, everyone. My name's Helen Bernstein. I'm Council Program Development in the Department of Professional Development and Competence at the Law Society. Welcome to this morning's program, Splitting the Pie, Dividing Assets When Married and Unmarried Partners Separate. We want to welcome everyone attending in our lecture hall in Toronto, as well as those watching from our Interactive Learning Network locations all across the province: Barrie, Brantford, Hamilton, Kenora, Kingston, Kirkland Lake, London, where we also have a presenter, Niagara-on-the-Lake, North Bay, Ottawa, Peterborough, Sault Ste. Marie, Sudbury, Thunder Bay, Waterloo, and Windsor. I just want to go over the way that we're going to be doing the questions because we have so many locations as well as the Toronto location. We'll be taking questions and rolling through each of the Learning Network locations first, and then we'll take questions from Toronto. Questions in Toronto will be on the mics that will be in the aisles. During the question period, we ask the people in the Learning Network locations to sit where the camera can see you, and please respond with your location name when it's called so that we know that we've gone through all the locations. Presenters in Toronto, when a question is asked in Toronto, will repeat the question for the benefit of those on the locations. As we embark down the new interactive learning road, it's more important than ever that everyone take the time to complete the grade course evaluation form that's in your file. Please note we are, as before, recording this program on video. Finally, we'd like to thank the chairs, Andrew Freedman and Lorne Wilson, and all our presenters for all their efforts in putting this program together. Andy is a partner at Colin Partners, a chartered accountant, a chartered business valuator, a senior member of the American Society of Appraisers, and a member of the ADR Institute of Ontario, and a widely noted author, as is Lorne, who is also a partner in the Family Law Department in the Toronto firm of Tork and Mains. So please welcome your first chair, Lorne Wilson.
Good morning and welcome. We have a information-packed program this morning, and we're going to try to move it along very quickly because we want to offer you as much as possible. The presenters' biographies are in the materials, so we will let you review those at your leisure. And again, we've asked each of the speakers to conclude their remarks 5 minutes before the designated time on your agenda so that we'll have an opportunity to take questions. What you weren't told by Helen, and you won't see in Andrew's biography, is that when the Globe and Mail decided 6 weeks ago that they would report on the top chartered business valuator in North America, we were all delighted to see that it was none other than our friend Andrew Freedman. Notwithstanding their accolades, Andrew is still a nice guy and is reasonably humble, and we were delighted that he was able to break time for his international tour to be with us for a few minutes this morning. Andrew.
Thank you, Lorne. I wasn't expecting that kind of introduction. Welcome, everybody. Today's program is also summarized in the materials that you have in your binder. Every speaker has prepared materials for you, and I think they're a useful reference source for you in your practice. The subject and the theme of today is splitting the pie on marital dissolution, and in that vein, each speaker is responsible for some aspect of splitting the pie, how to make it and how to split it up. And our first speaker, Patrick Schmidt, who I'm sure everybody in this room and who is listening knows about or has had the opportunity to meet in court or otherwise, is going to speak to us about the ingredients that go into the pie and give you some of his perspectives on financial disclosure. So we'll call on Patrick as our first speaker.
Good morning. My firm just spent the last 5 days down in South Beach having our annual firm retreat, so I'm intellectually exhausted. And to be first on this morning to talk about production and disclosure is a challenge from my perspective, although as Andrew says, well, at least you showed up. I found this particular topic to be somewhat difficult because the simple answer to the question is you produce everything that you need to produce that's relevant to an issue in the action, and you make sure that you obtain everything that you need to prove the elements of your case. Read Rule 30 of the Rules of Civil Procedure if you're under that regime. Read Rule 19 of the Family Law Rules if you're under that regime, and read the text that was done by Andrew, Sue Loomer, Vivian Alterman, and Paula White, Financial Principles in Family Law, Chapter 42, and that's what you need to know about production. And that sounds a bit trite, but that's it in a nutshell. The problem breaks down, as with any other principle, in the application of the principle. And when you put your signature on your client's affidavit of documents underneath his or hers, saying that you have advised your client of the necessity to produce all documents relating to or relevant to an issue in the action, that single stroke of the pen is, I think, oftentimes not seen with the level of importance that it ought to be. You have an obligation from the very moment your client walks in your door under Rule 4 of the Rules of Professional Conduct. So when you sign that affidavit of documents saying that you have complied with your obligations, what you're saying, Rule 4.01 of the Rules of Professional Conduct says where the rules of a tribunal require the parties to produce documents or attend on examinations for discovery, a lawyer, when acting as an advocate, A, shall explain to his or her client, 1, the necessity of making full disclosure of all documents relating to the matters in issue. Goes on to talk about discovery. B, shall assist the client in fulfilling his or her obligations to make full disclosure. And C, shall not make frivolous requests for production of documents or make frivolous demands for information at the examination for discovery. So how do you fulfill your duty? It is not, in my submission, the practice that seems to have developed in some centers where you send counsel opposing a 5-page list of documents that someone has created that covers every single possible issue that could be raised in a case, leaving it up to you then to say, no, we're not producing that, no, we're not producing that, that's too many, you don't need 10 years of tax returns. In my submission, that kind of a request for production does not meet the obligation of counsel to not make frivolous requests for documents. And tactically, it sets the whole case up wrong from the very beginning. Because as you know, these days, when you walk into a courtroom and try to argue that you shouldn't have to produce something, you're going to be facing a lot of very blank faces. The court, in my experience, exercises very little discretion against production. So if you have a 5-page list that is sent to you, I got one a couple of weeks ago from a law firm in Hamilton, and I looked at it, and you know, my natural inclination is probably to say no more often than I should, but I looked at this list, and a good 60% of it wasn't applicable to the issues in the case, and the other 40% probably went way further than what it should have been requested. But the dynamic that's set up right off the bat, when you go into that first case conference, the other side says, well, we've requested production, and Schmidt has said no. And that's a bad dynamic to walk into, particularly depending on what judge you're going in front of. It seems to me that the process works much better rather than starting off with this blanket demand for documents, most of which you probably don't have at an early stage. In a case of any complexity, you won't have all of your valuation day documents. You may not have all of your income calculation documents, and you certainly won't have your client's expense documents to verify if there's a claim for spousal support. And that's one of the reasons why the rules of civil procedure say that it's only after the pleadings are closed, within a certain time frame, you deliver your affidavit of documents. And in that context, or similar context, under the family law rules, there is no obligation to deliver an affidavit of documents until that is requested by the other side. So the time is permitted to allow you to assemble the documents. I find, particularly in family law, although it seems to be quite prevalent in personal injury as well, that the obligation to deliver an affidavit of documents is honored more in the breach than in the reality. And it's easy to say that's a custody case, so what do we need an affidavit of documents for? Well, in my view, it's extremely important, particularly in a custody case, that you do get an affidavit of documents. The affidavit of documents has to be prepared with some care and attention. I mean, it's obvious that in Schedule A, you're supposed to list the documents, describing them as originals or copies, what they are, what date the document bears, so that they can be easily identified. The practice of listing as document number 1 a brown manila folder containing documents with respect to 91 Ascot Avenue is not in compliance with the rules, and it's very dangerous for you as the party who receives an affidavit of documents like that, particularly if there's an issue about 91 Ascot Avenue. You then have to go and see what's in that document. If the documents are not articulated correctly in the affidavit of documents, when you're at trial, you're going to have a great deal of difficulty keeping out a document if the other side can stand up and say, well, it's right in this brown folder that we identified as production number 1 in our affidavit of documents. It's not certain you're going to be able to keep it out in any event, but if you haven't insisted on a further and better affidavit of documents, setting out the precise documents relied on with particularity, you're going to have no chance of keeping it out. Schedule A is easy. Schedule B is more difficult with respect to documents over which you claim privilege. It is not sufficient to simply put in the little summary that says all documents and correspondence passing between counsel and third parties for the purposes of this litigation. You actually have to set out and list each and every one of those documents by date and nature of document, from whom to whom. You don't want to produce it, someone else will make that decision for you. Schedule C seems to be completely abandoned in terms of documents that you used to have in your possession but no longer have. It's important that that also be complied with. That all sounds trite, but that is what you must do in terms of fulfilling your duty under Rule 4 of the Rules of Professional Conduct. The lack of particularity in an affidavit of documents should set up 3 or 4 red flags for you, that there may be documents in there that are hidden. I've had cases where you actually go over and pile through storage boxes full of documents that are identified by a particular property, and you find gems in there. You may find a canceled check to a travel agent that when you call the travel agent, at least it tips you as to a potential witness at trial, and you find a wealth of information out. There's all sorts of things. So you have to go and look at the documents. These days, because of the few trials that are being held, I think people have a tendency to underestimate the importance of actually going to the other person's office and reviewing those documents. Even for purposes of pretrial or preliminary motions, it's very important that you do that. When you've got a claim for an equalization payment, the production issues are pretty straightforward. You know what you've got to do. You know where you're bearing the primary onus for exclusions, date of marriage, property. The problem comes when, for example, you have a difference between the two parties in terms of the valuation date that they're relying upon. And you have to demonstrate the kind of life that those two people led during the period of time of the disputed valuation date. And you have to get into and produce documents that are going to satisfy the court that the parties were living together with or without some reasonable prospect of resuming cohabitation. You're getting into things that are fairly obvious, but of tremendous applicability in that situation, like credit card bills and where did they go for dinner and who did what. So it becomes an expansive process. When it comes to some specific items with respect to the issues of equalization payment, if there's a trust that's involved, make sure you get the letter of wishes, particularly if it's a discretionary or spendthrift trust. Excuse me, I just have to get some water. You need to know what the settlor said he or she wanted to do with the trust. And very rarely do people ask for the letter of wishes. You also want to get a schedule of the underlying assets of the trust so that you know what you're talking about. When you're dealing with real estate agents and there are commissions claimed as being owed at valuation date or date of marriage, make sure that you don't accept the monthly commission statement that embodies either the date of marriage or the valuation date. Make sure you get the precise breakdown of whether or not those expenses that are on that statement claimed against those commissions are that month's expenses, because the way it works as if you're a real estate agent, by the time you get your commissions on closing, the expenses related to those commissions have been spent perhaps 3 months beforehand, maybe 6 months beforehand. They're not a proper deduction against the commission income. So you want to make sure that you're dealing with the asset in its pure form without improper offsets. If you feel that the other side has not made full and proper production in their affidavit of documents, don't be afraid to bring a motion to the court for a further and better affidavit of documents. When there's a claim for spousal support, you've all been practicing in this area for enough time that obviously you know what you need to get is the income information for the claiming party. You're obviously going to want to get the income information for the party against whom you're claiming support. You're going to want to check what the expenses are to determine whether they're reasonable or not. The question that comes up most often in the case is how many years of income tax returns, how many years of bank statements, how many years of credit card statements. There's no easy answer to what's right or wrong on that. You just have to use your common sense. If there's a claim for current but not retroactive spousal support, whether it's under the Family Law Act or the Divorce Act, why do you need to produce the last 7 years of tax returns in that regard? There's no apparent answer that jumps to mind. So you just have to use your common sense. When you're dealing with a spousal support claim in a common law situation, whether it is same or opposite sex partners, the level of production that you're going to want becomes extreme. Based on the Milotovich decision, in terms of the factors that the court is going to consider in terms of deciding whether or not two people are cohabiting in a relationship that gives rise to economic responsibility by one to the other, the nature of their life is analyzed in the extreme, and you have to articulate and go through Milotovich and see what the factors are and make sure that you get the documents that are going to help you with that. So if, for example, there's a claim that we have been cohabiting maybe not even continuously for 3 years, but we've been cohabiting in an economically dependent relationship for the last 14 years, although I was away at university for 5 of those years, don't think you're not going to be vulnerable to the court finding that there's a cohabitation that exists that gives rise to economic responsibilities. And you have to get all of the documents. How did the two people deal with each other financially during that 14-year period? Were there bank loans that they undertook? It's an expansive exercise because you're looking at lifestyle. The other thing that comes up often, at least in my practice, is when there's a claim for spousal support, I instruct my client, if he or she is the claiming party, right off the bat to start keeping a ledger, start keeping all the receipts, buy an accordion file, make sure that all those receipts are kept. And I do that for 2 reasons. First of all, as you prepare your successive financial statements, if each one successively is based on estimates, you're going to get caught at some point in time because somebody's going to be able to demonstrate in cross-examinations that the estimates have been historically incorrect in the 2 or 3 years of the litigation. The first one may be based on estimates because of the time factors. The second, the third, the fourth, they shouldn't be based on estimates. Your client should be able to go through the accounting exercise and say, these are my actual hydro accounts, these are my actual phone bills, these are my actual food bills, and have those documents available to justify what's claimed in the financial statement. The second benefit that flows from that is when you go into cross-examination with someone who is an adept cross-examiner, the issue of the expenses of the party claiming support may be quite immaterial, but the issues relating to custody and access of children may be extremely material. And you've got a very nervous client that you're showing up with for examination, and the first thing that an experienced cross-examiner like Lorne, for example, will do is he'll want to shake the confidence of my client. And the best way of doing it, to give you a trite example, is going through the expenses, asking the client, well, what did you include under entertainment? And then after they've given this prolonged list, then say, what did you include under recreation? Because he's going to get the same list if the client's not properly prepared. And the power imbalance that's created by that works very effectively for him, because then after he gets finished these relatively immaterial areas, and my client's confidence is completely shaken, he or she thinks they can't answer the simplest of questions, then he moves into the areas that are really of interest to him, like custody and access. It's amazing to watch the shift in power that takes place in a cross-examination where the lawyer wades into the client's expenses and is met with the accordion folder, the ledger, and the actual receipts. That area of the examination is left very quickly. So I find that a very effective tactic. Thank you. I didn't think I'd make it that far. Custody issues. I've had, in the last year, I had a 6-week custody trial out in Brampton before Justice Belgium, and a 4-week custody trial in front of Justice Wine, both out in Brampton. And the importance of an affidavit of documents in a custody case was never brought home to me more than in those 2 cases. And I admit that in those cases I accepted an affidavit of documents from one party in one case that was where I didn't follow my own rule. I didn't go and actually look at the documents because I was getting affidavits of documents up to and including the day before trial. The level of diaries, cards, emails, tape recordings that are capable of being produced and allowed into evidence in a custody trial makes the affidavit of documents and the particularization of the Schedule A documents extremely important. You know, you've all heard, if you've done trials in this province in the last 10 years, how the rules of evidence are softened when there are issues of custody. Unfortunately, that proposition has been extended to any other issue that also happens to be in a case where custody is raised, and the response you're getting from judges these days is it all goes to weight. Well, the answer is no. If it doesn't get past admissibility, it doesn't get to weight. You don't have much of an argument on admissibility if you haven't asked for an affidavit of documents. You can't complain about the late production. And one of my clients got killed with a diary in that case. And it's extremely important that you identify those documents well before you go into trial. If your client is complaining about how his wife or her husband or spouse was an uncaring parent, an uncaring spouse, and at trial you're faced with the last 4 years of cards and photographs, it creates an atmospheric problem. So if it's not in the affidavit of documents, you can have a shot at keeping it out. If it is in the affidavit of documents, at least you've had a chance to review it. If you don't ask for an affidavit of documents, you're going to not succeed. I think the last area that, just to touch on in terms of specifics, if you have a significant period of premarital or it's only in the pre-marriage situation where there's cohabitation and you want to advance a constructive trust claim against one party's date of marriage assets because they've accumulated assets of value during that period of premarital cohabitation, whereas the other party spent their money on things that were consumed. making sure that you get production of the lifestyle documents and the financial documents for that period of time of premarital cohabitation is very, very important. And obviously, you can understand the effect that has on one's date of marriage property. Lorne, I'll finish now and see if there's any questions.
Great. Thank you very much. What we're going to do is we're going to run through the various locations, and I'll just give the name of the location. If somebody at that location wishes to ask a question, just speak up, and otherwise we'll move on. Any questions from Barrie?
No, thank you.
Brantford?
No, thanks.
Hamilton? Kenora? Kingston?
I thought they might.
Is there a question from Kingston? No. Kirkland Lake? London? Niagara-on-the-Lake? North Bay? Ottawa? Peterborough? Sault Ste. Marie? Sudbury? Thunder Bay? Waterloo? Windsor? Toronto? Yes, question.
In children's cases, on a trial, how often do the counsel for the respondent parents request an affidavit of documents? We just went through a trial where we didn't have an affidavit of documents, and documents were being produced throughout the first week of trial.
Not often.
Is it common to ask for it?
Sure. Well, you can and you should.
These are in CFSA cases,
Yes.
though. So is it common, or is it a rare?
Well, you're touching. I don't do. I haven't done for a long time CFSA stuff, but I know the problem you're talking about, and there's nothing precluding you from demanding it. And it seems to me it's just to provide the necessary safeguards. Having just gone through it, you can understand the problems you face.
Yes.
I mean, the whole design of the rules, whether it's under CFSA matters, family law rules, or the rules of civil procedure, was to avoid trial by ambush. I mean, that's been a fundamental precept and the theory behind our rules for now some time. Unfortunately, these days it seems to be trial by avalanche, but trial by ambush still exists and in some discrete areas like you're talking about. And I don't think you should permit that to happen.
Okay, thank you.
Any other questions from Toronto? If there are, could you just come up to the mic, please? While we're doing that, I know I went through the list fairly quickly. If there are any other questions from any of the other remote locations, perhaps you can let me know now. No. Toronto question?
Yes, good morning.
Did they bring a list?
I have a problem about producing tapes where the husband, my client, has a series of tapes, and we have transcribed them, and they're pretty damning in that the mother made phone calls before leaving the home from their home telephone and discussed all kinds of sexual behavior with strangers and laughing with her girlfriend about how she was pulling the wool over her husband's eyes. But immediately beside the woman is her 4 or 5-year-old son hearing all this, and amongst the conversation she was teasing a boyfriend, and he says to her, "What are you wearing?" And she says, "Nothing." And then he gets a reply from the woman when he questions that and says, "Nothing?" She says, "Jake, come here. Tell him what I'm wearing." "Your panties." Well,
Sorry, and it's your client who has made these tape recordings?
yes,
And
but
your client is the husband?
yes, but
Right, and
it's
your
it's
problem
in
with
their home, but
producing
I don't
these is
think,
what?
I don't think she knew that she was being taped.
Well, obviously.
It's on his answering machine.
And you're worried about the fact that this is a tape
Maybe a
recording of the
criminal-
conversation between
yeah.
her and the third party?
Yeah.
It's a problem.
You bet. I got an opinion from Barry Fox.
I had a case, a custody trial with Alan Poole, I think in 1983. He's acting for the husband, I was acting for the wife. The husband put a tape recorder under the bed. And it was very well set up, and just about every issue that was in play, including my client's alleged instability, was raised in discussions in the most intimate of settings where there was an expectation and a willingness to be candid. And those went in, obviously, because they were simply recordings of conversation between the two parties. But that's what your client did. If he had taped his wife, whether she knew it or not, that's not a problem. But when she's talking to a third party, that's a problem. And I think your client has a risk there if those things come to light. Your question is, do I put them in the affidavit of documents?
Essentially.
Right. Well, that becomes an even bigger problem because your client has an obligation to produce anything that is relevant, not whether it's admissible.
Yes.
And I guess the end result is if you do something that you're not supposed to do and you have evidence of it, and it might be germane to, let's say there were custody issues, and it might be germane to your client's attitude towards his wife, and it may say something about him, he risks the fact that somebody's going to look at that and maybe charge him.
Yeah.
But I think you have to produce them.
Well, the other side, when I hinted that there might be such tapes, certainly pounced upon the criminal code in a big rush. So it's a dilemma.
Well, but it creates a real problem for you because you know about them. How do you fulfill your responsibility?
Do you want a client?
Because that's
Pat, I have a question for you. One of the problems I have in my practice is drawing the line between documents that are relevant to an issue in the litigation and a fishing expedition. And we've all been on both sides of that issue. One of the examples that comes to mind are cell phone records. Cell phone records are a wonderful source of information as to who people speak to in their unguarded moments. And sometimes it's a wonderful way of finding out, who is the girlfriend or the boyfriend and when did the contact start and where were the calls made from. And you said you were in business in London and the cell phone was made from Vancouver, and it can relate to financial issues as well. Where do you draw the line, Pat, in terms of what's relevant and what's a fishing expedition? And maybe secondly, do you have any particular words of wisdom in terms of how you deal with things like cell phone records? Is it automatically in your wish list when you're the hunter? Is it automatically protected when you're the huntee? How do you handle these?
You ask for everything and give nothing. I don't think there's an easy answer to that particular one. I mean, it depends what the issues are. I mean, if there's who the girlfriend, boyfriend is wouldn't be particularly relevant unless, for example, there was some disagreement about valuation date. So I guess the simple answer is it depends on what the issues are. If there was a custody and access issue, I'm not sure that the identity of that person is particularly relevant either. The fishing expedition problem, I think, is more difficult. It oftentimes takes the form of a request for the last 7 years of someone's bank accounts, credit card records, and you have to ask yourself, what's the point? I mean, I understand if there's an allegation of there being assets that have been moved offshore or to some secreted place, it becomes very relevant. I have an examination this afternoon in a case that Marty Teplitsky's on the other side of, and I was doing the examination of his client, and I got 3 banker's boxes full of bank documents, and I'm going through them. They were produced about an hour before the examination started, so I just sort of looked at the most recent ones. That's no criticism of Mr. Teplitsky. It was his client who brought them into the examination. And I'm looking through the bank documents, and I see 3 dispositions out of a bank account of $100,000 each within 6 days preceding the separation. And so I'm looking at that, and I asked the fellow what that's about, and he says, I owe some money to somebody. And I said, well, who is that? And he says, Simon Templar. I said, Simon Templar as in the saint? He says, no. He says, who? And I said, it was a joke. He didn't get it. And so anyway, Simon Templar is some unidentified individual who lives in New Jersey. And the explanation given to me was that he had met this fellow at a conference, and this fellow was interested in playing the exchange difference market, and what he would do is send money up to this fellow who would then deposit it into the Bank of Commerce and then on request convert the US dollars to Canadian dollars, and he would be able to keep the interest but remit the principal. And of course, you know, don't need to do that to play the exchange differential. And I said, well, how long have you been doing this? And he said, well, you know, it's been a number of years. So suddenly, the production of all of his bank records for the past 10 years becomes extremely relevant. So you can go through and track these dispositions. It was fought as a fishing expedition. The court ordered it because he ultimately took the protection of the Evidence Acts on the examination, which he didn't need to do, but it's always a nice atmospheric thing to have on the record. And the court ordered the production, and we're getting there. So I'm finished. So I don't know if that answered your question, but it's the best.
Thank you very much.
Our next speaker is Paula White. Paula is a chartered accountant and a chartered business valuator and a partner at Cole & Partners. Paula is going to talk to us today about practical valuation issues, and these relate to what size of the pie to bake. Paula?
Thank you. Good morning. We're going to keep things hopefully very practical. I'd like to talk about some valuation issues that we encounter quite frequently in small businesses and in valuing professional practices. Talk about some issues that often come up and how we deal with those issues and what it means to you when you're reading a valuation report. The first issue that is often coming up in small business valuations. And when we talk about small businesses, we're generally talking about businesses with sales of under $2 million. So these are quite small, usually owner-managed. They don't need an audit, and that can be a problem for us and for you. The next issue is usually owner-manager remuneration, personal goodwill versus commercial goodwill, is another issue. Okay. Financial statements that are issued by a chartered accountant can take one of 3 forms. They can be what are called compilation engagements, which are notices to reader. So when you flip over page 2 of the financial statements that you get, you'll see what's called the transmittal, and it'll tell you whether a financial statement has been a compilation engagement, a review engagement, or an audit. And the lowest level of assurance that an accountant will give is the notice to reader or compilation. And it's actually no level of assurance. They've simply taken the bookkeeping records that the client has provided and put them into a format that looks like a financial statement. And it is a financial statement, but it has not been subject to any sort of review or audit. And the accountant hasn't undertaken a review of the internal controls of the business and has not audited anything. The next level of assurance is sort of a medium level, and that is the review engagement. The review engagement allows the accountant to check for reasonability. They might quasi-audit a few key numbers. They do not do a full audit. They check for reasonability, and they issue what's called a review engagement report. And you can see that also on page 2 of the financial statement. The highest level is an audit. You don't see these very often in small businesses unless there's significant bank debt or there are partners who require an audit. There's no statutory requirement for an audit for these small businesses. And even at the audit level, although it's the highest level of assurance, and we would like to see that all the time, as we all know from recent events, it's no guarantee. So what does it mean when we encounter financial statements that are usually notice to reader financials for small businesses? We might be forced to rely on these because it's not efficient or practical for us to go and audit the business. So we then have to rely on financial statements that can be inaccurate, misleading, or misstated. Sometimes parties will point us to areas in a financial statement that they feel are clearly misstated. So a spouse will say, listen, I know that the promotion expense is all personal. It has nothing to do with the business. And we might be able to go in and do an audit, so to speak, on that particular item. But that comes with a very high cost. Bookkeeping is very tedious, very labor intensive. For us to go in and audit anything is incredibly time consuming and usually very expensive. And before undertaking that, it's worthwhile to sort of have a look at the cost benefit of doing that. Okay. In those instances, it's often difficult to meet client expectations, and that's an issue for both of us. In most small businesses, there are no internal controls. So whereas in a large business, you would have the accounting department making sure that all the checks that are written are supported by the bill of lading, somebody signed for it, it was an appropriate purchase. In a small business, you don't have that. The owner manager can override all the controls. They can tell the accountant to write a check every week to their personal trainer and put it through as wages on the books. And nobody catches that unless there's a really good audit done at the end, which there isn't usually. So you might have, because of the lack of internal controls, it's very easy for owner managers to misstate financial statements, to put in financial or personal expenses, to defer income, hold off on billing, or to inflate the expenses. Okay. Another issue that usually comes up is the determination of the appropriate level of owner-manager remuneration. When we do evaluation, we typically look at adding back all of the remuneration paid to the owner-manager, and then deducting in the valuation the economic level. What would you pay to a third party to do the owner-manager's job? And that requires a little bit of investigation. You have to look through the financials to figure out the whole picture. You have to talk to the owner-manager and perhaps their accountant to figure out exactly what line items are really related party expenditures, what was a bonus, what were personal expenses, and add it all back, and then undertake some research usually, either by looking at salary surveys or talking with owner managers in similar businesses to figure out what would a market salary be for this particular person. And that's not a terribly scientific procedure. So you have to talk to the owner manager because oftentimes they're working 7 days a week. They're doing the jobs of 2 or 3 people. So it may in fact take more than one person to replace the owner manager, and something you have to understand, and you should look at it. You can refer, evaluators do refer to salary surveys. They're very generic, so you have to be careful about using salary surveys, but they are a good place to start usually. The last issue we're going to talk about with small businesses is personal goodwill versus commercial goodwill. Where we talk about goodwill being transferred in a business, that is automatically commercial goodwill. People pay a purchase price that might include commercial goodwill. They will not pay for what we term personal goodwill. And personal goodwill is, if you think for a minute about, let's say, a litigation practice for a criminal lawyer. And the reason that particular lawyer gets work is because of his reputation. You can't transfer that reputation to somebody else. So although the business might be terribly profitable and there's a lot of goodwill, it is personal to the owner. It cannot be transitioned off to somebody else. And that's sometimes difficult to ferret out. So the evaluators have to understand the business, they have to understand the industry, and they have to segregate those two items. In figuring out personal versus commercial goodwill, the evaluators make certain assumptions, and we assume that the owner will cooperate with a notional sale. So they will sign a non-compete agreement. They may sign an employment contract to stay on for a little while. They will help in the transition. So if the type of business you're looking at is one where there are really tight client relationships, and the owner-manager says, well, these are all relationships. If those relationships could be notionally transitioned off to somebody of equal skill and knowledge, then we would assume that the vendor would cooperate in making that transition possible. So it's not good enough. It doesn't mean that there's no commercial goodwill just because those relationships are with the owner. There has to be more to it than that. Okay. I think we're going to finish early. Okay. In the valuation of a professional practice, so we have law practices, dental practices, accounting practices, and such. The issues we usually come up with are, again, personal goodwill. The calculation of goodwill is usually based on the excess earnings method or a rule of thumb to some degree. And another issue we often come up against in professional practices is unrecorded work in process. So again, just keeping with professional goodwill for a moment, it's very common in professional practices. It should not be mistaken, though, or goodwill in a professional practice should not be mistaken for the value of a license. Okay, the value of a license is really the capitalized value of what somebody could earn if they stayed in practice. And that's a value to owner concept. You can't transfer your license to somebody else, and you have to keep working in order to earn it. So that doesn't qualify as commercial goodwill. The hard part for the evaluator is to understand the business, understand the industry, and really understand what drives the revenue. Is it the personal reputation of the practitioner, or is it the client base? If the factors relating to earning revenues are really inherent in the practice client base and can be transitioned off to somebody else of equal skill, then that would give rise to commercial goodwill. And if that's the case, the next step is you often see in valuation reports, you'll see reference to recurring revenues, recurring earnings. The job for the accountant or for the evaluator is to study the revenues and expenses, speak with the owner, and understand what type of revenues are going to continue each year. So for example, if it's an accounting practice, generally the annual year-end financial statements for all your audit, review, and notice to reader clients, those come up every year. You just keep doing it. So those would be recurring, and the expenses that go along with those would be considered recurring. If, however, the accounting practice last year took one of their clients public and had a huge bump in their revenue, that's something that is probably not expected to recur. And you would exclude that blip from the determination of future recurring earnings. And once you figure out those recurring earnings, you then have to come up with what we call the excess earnings. You take the recurring revenues less the recurring expenses, and you deduct from that again, or not again, but you deduct from that the owner-manager remuneration. So if it's a dental practice, figure out what the practice will make in the future, and deduct from that what you would pay a dentist to do that work. So if the practice makes $200,000 a year, but the market salary for a dentist performing the work is $150,000, then the excess earnings is $50,000, and that's what the goodwill will be based upon. So valuators take that excess portion, we capitalize it, we tax affect it, we capitalize it, and that's the goodwill that can be transferred to somebody else. We then add that to some of the redundant assets in a practice, the receivables, the cash, take off the bank debt and payables, and you get a value for the entire practice. One of the things we see often, however, is that a capitalization rate is hard to find because the transactions are usually not publicly available. So you have to build it up. One of the ways of getting around that is to use a rule of thumb. We don't love to rely on rules of thumb. They make certain generic assumptions about a practice. They might be out of date. We use them as a bit of a reality check. And we also use them sometimes where there are no excess earnings. You could have an accountant's practice that has a really good, strong, solid client base, lots of recurring revenues, but for some reason it just doesn't make any excess earnings. Does that automatically mean that there's no goodwill? It can, and what the evaluator has to do is analyze the client base, the manner of the practice to understand why there are no excess earnings. Sometimes it's because, let's say it's a relatively new practice and they've got way too much overhead. They just don't have the volume yet to fill up all their offices. So they're running an expensive practice even though they have a very strong client base. In those situations, a prospective vendor would likely pay some goodwill to acquire that client base even though there are no excess earnings in the practice. And in those types of cases, we might turn to, if we can't determine the excess earnings, we might turn to a rule of thumb to give us a rough number. Thanks. I think I'm almost done. Okay. However, if the reasons for no excess earnings are likely to be continued, then the rule of thumb is pointless and there just really is no goodwill. It's just a poorly managed practice. They're not charging enough. The nature of their client base isn't such that it gives them any goodwill. Okay. And if there's no goodwill, then the value of a professional practice is usually based on simply its adjusted book value, which is usually pretty straightforward, receivables, net of payables, that type of thing. One asset, though, in the book value that can be a little tricky is unrecorded work in process. So this is the unbilled work. You'll see this in professional practices. You'll also see this, you should watch for it in businesses where that are job related, so construction companies, things like that are job related. And you should always ask the evaluator, if the report doesn't make reference to unbilled work in process, whether or not they looked at it, because it can be significant. It depends on how regularly somebody bills. It depends on when the valuation date falls during the year. So if you're not relying on a fiscal year-end date, but 6 months into the year-end, the accountant won't have been involved. You'll be using interim financial statements. They might not have the unbilled work in process accounted for. This can sometimes be significant, and just make sure that the evaluators addressed it. We go to the bookkeeping records to get the unbilled work in process. We take off the tax that you'd pay on the profit, and we add it to the adjusted book value. And I think that's it.
Great, thank you, Paula. We'll go through the various locations for questions, please. If you're at a location, come up to the microphone so we can... I've been asked to give each site a little more time to respond before moving on, so I'll do that. Any questions at Barrie? Brantford?
None, thank you.
Hamilton? Kenora? Kingston? Kirkland Lake? London?
Is there any rules of thumb for professional degrees where a person is an employee of a company as opposed to an owner?
Unless the degree can be transferred, which they usually can't, there would be no value. It's generally a non-issue.
Thank you.
Okay?
Just dealing with that last question, I think the Court of Appeal in Carleton pretty well nailed down the door on the argument for professional licenses and degrees. Although, if you actually go back and read the decision, it was a fairly narrow decision. So if you had a good case with good facts, it's possible from a legal point of view, leave aside a business valuation point of view, that one might yet make that argument. So if you have a case where that's really your only argument and you can't get it in any other route, say compensatory support or equalization or constructive trust,
I don't know when he's going to retire, but maybe
do not work for you, you may want to try going back and looking at Carleton and see what part of the argument still may suffice.
Problem too is depending what date.
Any other questions at London?
He's
Thank
kept
you.
a friendship relationship, like she calls.
I have a question.
Is there a question?
Rule of thumb for law versus dental versus doctors versus accountants. Or the
Sorry, whoever's asking the question at London, could you start again, please, and a little louder?
The question isn't coming from London.
All right, next, Niagara-on-the-Lake,
He's allowed to fix this.
North Bay,
Unless you had another one.
a law versus small.
Ottawa, Peterborough, Sault Ste. Marie.
Yes, I have a question from the Sioux.
Yes?
I thought the previous questioner was going to ask about whether or not there was a rule of thumb between various professional practices, for example, law, dental, doctors, and accountants. I know it can't be very specific, but do we find that there are any rules of thumb that can be helpful when we're dealing with those types of professional practices?
By himself?
There are rules of thumb for all of those. I'll just give you an example to show the weaknesses, though. General practitioner medical practices used to have a rule of thumb, and it was based on a percentage of revenues. That rule of thumb is no longer applicable. GP practices, medical practices in Ontario generally these days have no goodwill value. That industry has been decimated. Profits in that industry have been decimated by recent political events. Not recent, but over the last 10 years. So you have to always have a look at how old that rule of thumb is, whether people are still relying on it. You have to have your hand a little bit into the industry to find out what's really going on and are people really using it, because they can be very outdated and inaccurate. On the other hand, there are some rules of thumb that are a little more reliable. Let's say, for example, dental practices. General practitioner dental practices, generally rule of thumb for the goodwill portion is anywhere from 30 to 50% of recurring revenues. Accounting practices, you know, there is a rule of thumb. It's anywhere from 40% to 100% of recurring revenues, and I'm not sure how useful that is. Okay?
Thank you, Paula. Any other questions from Sault Ste. Marie?
No.
Sudbury?
It's really a case by case.
Thunder Bay?
Yes, I have a question.
Yes, go ahead.
Yes, it's Mike Carter in Thunder Bay. I have a question about where financial advisors might fit in with rules of thumb. Seems to me they're somewhere in between a professional practice and a business, and wonder if the speaker had any comments about that.
There are rules of thumb for financial planners and investment advisors, people who deal with mutual funds. There are rules of thumb. They're similar to those in the dental industry, actually. They also, though, depend on a thorough understanding of what's going to be recurring. And you have to look at the trend in sales of those types of practices. In the late 1990s, there were a lot of sales of these types of practices at very high values based on reflecting rules of thumb that were quite high. I'm not sure that those rules of thumb would be applicable in today's environment.
Financial advisors.
Waterloo, any questions? Windsor?
Lost everybody else's money.
I have a question in London.
Yes, please go ahead.
Where do you get access to these rules of thumb, just so we can familiarize ourselves with those?
It's a secret.
It's a secret.
It is. We generally canvass people in the industry. We review a lot of trade-type journals. We just by contacts. Sometimes there are actual transactions or surveys. There's a BC survey dealing with accounting firm sales, but I don't think that's been updated in several years. But so generally, it's pretty hard to find.
Thank you.
Paula won't tell you this, but rulesofthumb.com is an excellent source of that information. Any other questions at Windsor?
I have a question in Windsor.
Thank you. Go ahead.
What inherent difficulties would you expect in my personal favorite industry, the truck driving industry? How would you approach evaluation that way for a self-employed truck driver?
It's all personal goodwill. It's really tough. In those instances where you have a self-employed person, the cost-benefit has to be looked at. It's very difficult to find the true revenues. If you're talking about people who can deal with cash, people who can, alter their financial statements at will, it's very expensive to try and figure out what's really going on. But for more established trucking businesses, then it would be it's a different story.
You got to go through when.
Any other questions at Windsor? All right, Toronto, any questions, please? If you have, please come up to the mic. Yes, question over here.
You've got a case where an individual, say a lawyer, whatever, self-employed, and as you say, it's very expensive to involve your type of profession in it. Is there a sort of a database at Statistics Canada or anything like that where one can look to at least get a general idea of what, say, self-employed lawyers after X number of years are earning on average before we decide whether it's worthwhile to tell our clients to maybe spend the money to hire someone like you?
I think in the valuation context, the answer is no, because what one lawyer should be earning based on statistics versus what they actually are earning given their practice, I think it would be very difficult and very expensive to get over that chasm. For guideline purposes, that's a different question, for income purposes, but for valuation purposes, I think it's not practical for most self-employed people. You're probably a little better off in that instance doing a mini audit of some key areas.
Just one suggestion in part answer to that question. Very often there's a whole range of engagements that you may want to consider hiring someone such as Paula or Andrew or any other business valuator to do short of a full valuation. Regularly I'll call up Paula or Andrew and say, can I buy an hour of your time, and basically give them a summary of the information of the case and say, what do you think? I'm not asking for a written report, and obviously it's only as good as the information I give them and the amount of time they have. But sometimes, based on their experience, they can say, it looks very unlikely that we're going to find any significant value, or it looks all personal. And so sometimes that small little quick and dirty look can be helpful to you and your client to make the decision of, do you go any further? Which is certainly better than not even taking that step. Okay, there's another question here in Toronto.
Paula, with regard to your comments on medical practices and valuing medical practice, and make a difference on the degree of specialization, is there less value to a specialist like a psychiatrist practice?
The more specialization you have, the less commercial goodwill there will be. So the more highly specialized somebody is, the more personal goodwill there is, because all of their work then comes to them usually from the medical community and based on their particular personal reputation. It is not based on their existing practice where people walk in off the street, or there's a client base that comes back every year. Sometimes though you could have practices like, let's say, a psychiatry practice where there is a client base that's established, that is regular, that has maybe a 3-year average lifespan to it. And it might be, in that instance, there might be some value to an equally qualified psychiatrist who's a general psychiatrist coming in and taking over that practice. But if it's somebody whose referrals are obtained within the medical community from their own specific reputation and there's no ongoing relationship with that client, they're all sort of one-offs, then I would say there's no commercial goodwill.
Paul, I have a question for you. In Ontario, there's a fairly active market in buying and selling dental practices, and very often I see these reports from dental brokers who apparently are quite involved in this, and very often dentists will go to them to get a valuation report of some sort. What, if any, use are these reports from dental brokers? Are they helpful? Are they more misleading than useful? How do you deal with a situation when that's thrown in front of you, either by your client or the other side?
Depends on the broker, but generally they're helpful. You have to be a little bit careful because they're not necessarily independent. They're not at all independent. So they're trying to give a value generally that's helpful to the owner. And we find them helpful. They usually contain a lot of detailed information that is easy to obtain from looking at their report rather than digging it all up ourselves. You have to be a little bit careful with them. It's worth it, I would say, to have a evaluator look them over rather than relying on them, just on their own. But we do find them helpful, and generally what our experience has been that they're not way off base.
I think we have time for one more question from Toronto.
You talked about financial statements and the level of assurance you can get from the way different financial statements are put together. Can you talk about the level of assurance you can get from different kinds of valuation reports and the way they're put together?
Valuation reports, this CICBV, which is the Canadian Institute of Chartered Business Valuators, lists standards for valuation opinion reports. And as far as they're concerned, that's the only type of report evaluators should be issuing. An opinion, like the chartered accountant sort of trio, is the highest level of work we could do. And that is usually too expensive for your average small business. And it's generally, you won't get any sort of benefit out of going the extra mile. We often do what we would call estimates, which are not necessarily good enough for court, but which provide a decent amount of work and a good range of value for people to use in figuring out their net family property without going to the expense of an opinion report. And as Lorne said, sometimes, we'll do an off-the-cuff, quick and dirty, here's a big ballpark range of what we think it is, but we won't put that in writing. And so we often do for small businesses the estimate report. But again, if you're pretty sure that you're going to go to court, it might be worthwhile up front to ask for an opinion report.
Thank you very much, Paula. I didn't get to ask the question as to why these valuations are so expensive, but we'll leave that for another time. Our next speaker is Robert Halpern. Robert is a seasoned family law lawyer, partner at Tork & Mains. I understand he's the head of their family law division there. And Robert is going to talk about my favorite topic, deductions and exclusions from net family property. And in terms of our theme, he is going to tell us what size of each piece of the pie should be. Robert?
Thank you, Andrew. I was thinking about Pat Schmidt's talk. It was a natural segue into my topic, which is, well, what I'm calling Update 2003, Equalization of Net Family Property, Proper Inclusions, Deductions, and Exclusions. Because if there's one thing you could walk away with today, it would be the importance of marshaling the evidence, particularly through documentary disclosure, in an effort to substantiate a proper inclusion, deduction, or exclusion. Now, you might say, well, that's sort of trite. Of course, you have to marshal the proper evidence, but when I refer to some of the cases, you'll see that in a lot of instances, a judge says, no, that may have been a proper inclusion or deduction or exclusion, but you just didn't make your case out for it on a balance of probabilities. So I wish to open with that, as obvious as it is. In 1994, I presented a paper at a Canadian Institute conference called Combating Unfair Practices or Unfair Tactics in Family Law. And Schedule A to my paper, which is at tab 2 or 3, has the 1994 edition of the paper I'm presenting today. And I canvassed the cases on this subject at that time spanning 1987 to 1993. And this paper, that is the one that I'm presenting today, is entitled Update 2003, Equalization of Net Family Property, Proper Inclusions, Deductions, and Exclusions, and I'm seeking to canvass various of the cases between 1993 and March 2003 inclusive. I'm going to start with a few introductory remarks about the Family Law Act. I'm sure many of you are familiar with it, so I'll go over it very quickly, but a brief reminder couldn't hurt. The Family Law Act attempts to establish a delicate balance in terms of not being overly broad and vague, while not being too narrow and restrictive. And the result is it doesn't provide rules for every possible scenario that you may encounter, and hence we have case law in terms of, well, my particular topic. As you know, net family property under 4 sub 1, it's the value of all property except property which is expressly excluded that a spouse owns on the valuation date after deducting the spouse's debts and liabilities and value of property other than a matrimonial home that the spouse owned on the date of marriage, net of dates and liabilities. You're all familiar with that, that general formula, but in it are the critical terms that I'd like to address today. What are proper inclusions, deductions, and exclusions? Now, very briefly, inclusion is not actually a term within the Family Law Act. It's more of a term of art. Property, however, is defined under Section 4 sub 1 of the Family Law Act, and it includes any interest, present or future, vested or contingent in real or personal property. And for somebody like Andrew, it's a field day trying to find an interest, find an interest, be it present, future, vested, contingent, in the hopes of trying to assist a client to jack up an NFP. Deduction, also not specifically defined under the Family Law Act, but it's referred to in the definition of net family property, as I've just read, and it refers to 2 separate time periods. Valuation date, typically the date of separation, and marriage date deduction. Now, you're dealing with debts and liabilities at the date of separation, and the marriage date deduction, of course, is a deduction of net worth. Now, I shouldn't say of course, because judges often don't get that right. Excluded property, and I've set these out on page 3 of my paper. Most people understand them to be the property received during marriage from a third party that still exists on the date of separation, that you don't pour into the house, that the gift giver has expressly gifted to the person, and oh yeah, that will also include income if the gift giver, be it through a will or a trust, also says it's to be excluded. And it also includes property into which that can be traced. Now, you're all familiar with these things, I know, but in the course of the cases, it's not always obvious differentiating between the theoretical and the practical. There are also some other exclusions, such as the right to damages or actual damages from personal injuries, and that's been a hotbed for litigation as well, as I'll discuss, and proceeds or right to proceeds of a policy of life insurance. And of course, that which can be excluded through a domestic contract. There's even a case in the materials about, do you have a valid domestic contract actually excluding. So each one of these areas produces a lot of litigation, starting with the definition at large and then breaking it down into its component parts of inclusion, deduction, and exclusion. And again, I go back to Pat Schmidt. Evidence, evidence, evidence is critical because the Family Law Act is express in stating under Section 4.3 that the onus approving a deduction under the definition of net family property or an exclusion is on the person claiming it. And this attaches not only to the existence of that particular item, be it the deduction or the exclusion, but also as to establishing its value. There's no specific provision in the Family Law Act for the onus of proof in respect of inclusions, and the cases don't expressly state that the onus lies on the party seeking this particular declaration, but suffice to say, if it's to your advantage, you better prove it. Now, what's the standard of proof? Again, it might seem kind of trite, but it really isn't. It's again, the balance of probabilities, and it's subject to the best evidence rule. So do try and get the best evidence. There is some case law that says oral evidence may be sufficient. Courts are particularly more lenient on this point in the context of marriage date deductions, where it's a long-standing marriage and the documents just don't exist. But again, go for the best evidence. Now, before I get into the chart of the more recent cases in the last 10 years, I reflected on why is this sometimes a difficult topic? It might seem pretty clear. You've got this formula. It shouldn't be so hard. But sometimes, I discovered, the courts, in addressing the facts, have a certain lack of precision, with all due respect. They use the terms inclusion, deduction, and exclusion, sometimes in error. And some judges have, for example, referred to exclusions as deductions in the calculation of net family property. They've referred to non-inclusions as deductions when simply it's just a case of, well, we're not going to include it. It doesn't mean we're deducting it. I hope I haven't confused anybody. And they fail to appreciate that one can deduct a negative net worth on the date of marriage in the context of calculating net family property. And I think sometimes there's a confusion on the court's part that a negative NFP, that is a decline in net worth over marriage, is deemed under the Family Law Act to have a nil value, nil NFP value. They sometimes confuse that with the fact that you can walk into marriage with a negative net worth to come up with, in fact, an even larger NFP often. Sometimes judges, bless them, get the math wrong in their mechanical calculations after characterizing the property at issue correctly in their reasons, which of course causes you to wonder whether they actually did. But they've said the right words, they've just sometimes done the math wrong. So to combat this, what I do, particularly when going to trial, and believe in Toronto it's part of the rules, I attach my client's NFP to the opening statement, and I try to submit, with the other counsel's cooperation, a joint NFP circling those areas of dispute in the calculation of net family property, be it in the context of the characterization of a particular asset or liability, or the value. So a judge, all he or she has to do is plug in the value at the end. And in the opening statement, to the court, I try and characterize exactly what figure, from my client's perspective, should be plugged in where, and the impact on the calculation of his or her net family property, and the resultant impact on the equalization. From page 5, I'm sorry, I'm reading off my own paper, but excuse me for a moment. From page 3 sub 4, or 3-4, I apologize. I touch on various of the cases in respect of inclusions, deductions, and exclusions, picking up numerically where I had left off from my 1994 paper. That's why at inclusions I start at number 22. I'll just go through some of these cases, not so much for the holding on the specific facts of this case, but rather to alert you to the sort of thing the court is looking for in the practical application of these concepts. Under inclusions, and I'll refer to them by item number rather than the case name for ease of reference. Case 22, at issue there was the includability or the inclusion of an income tax refund. The court ultimately said it's not a proper inclusion, for right or for wrong, and there the court tried to differentiate between income versus property. So again, going back to the original formula, court characterizes a receipt of something as on account of income. It's not going to go into the calculation. In case number 23, under inclusions, a husband transferred certain assets to his mother just prior to the date of separation. Again, the court looked at it and tried to address the equities of it, and they clawed back the amount because they thought there was improvident depletion. And then on the opposite side of the same coin, case 24, you've got an asset which wasn't held in a spouse's name, but was ostensibly controlled by a spouse, and the court said, wait a second, we're going to claw that in on the grounds of equity. So again, evidence is critical in the context of the argument that you wish to make. Case 25 addresses the question of for whom is the benefit occurring. And at issue there were certain cases, certain assets, cash surrender value of insurance policies, certain chattels around the house, and the court examined for whom is the benefit. So in the calculation of net family property, going back to the formula, if there's an asset at issue which isn't for one of the parties, then it may or may not be included in the calculation. Again, always go back to the formula and focus on the best evidence. In case number 26, and this is a problem that the court deals with all the time in the context more of exclusions, and I'll refer to this later, is what is the nature of the property in terms of can it be tied to the marriage? Here, severance pay upon termination, somebody sought to include it, and the court said, and I'll touch on this a bit later, that where the asset relates to income earned during the marriage, in this case it was severance pay upon termination, doesn't flow to the person gratuitously by way of gift or inheritance, it's going to be included. Now, case number 27 addresses this as well. And I've tried to identify in the facts that I'm giving in respect to the particular case, the facts which you need to know for the particular asset at issue. Thank you. Item 28, shareholder loan. That's in there because it's a receivable. And you know from your financial statements that there is a specific category for accounts receivable, and it's unquestionably property. Item 29, that was the case I referred to previously about what's a domestic contract. Again, going back to the definition of exclusions. In that case, the court found that the note at issue didn't constitute a domestic contract. On the other hand, you might have something like in case number 30 where you're dealing with a proper inclusion, but it's the asset at issue is too de minimis in value for it to be included. In that case, the court said it would be absurd to deduct a value attributable to the short-lived ground floor apartment. Somebody was trying to carve off the part of a particular house. Now, item 31 deals a whole host of cases decided on valuing survivor benefits. And the key in those cases is one of predictability. And what I mean by that is if the court finds that it's reasonable to think that somebody will get a benefit in respect of a benefit based on the relative likelihoods of somebody's pension, say a husband's versus the wife's death benefit entitlement under that pension, they'll look at the evidence, again, going back to the evidence, and try and ascertain whether a value should be attributed for inclusion purposes. Case 32 dealt with an issue that came up just a few minutes ago in the context of transferable rights. There's a discussion about professional practice, not professional practices, but professional degrees, and the court held that where you've got, in this particular case, payments under a non-competition agreement which addressed a right to a future income stream, it's going to be included. The husband tried to argue that those particular rights were not transferable. He was proved wrong, so therefore his argument failed in respect of saying there wasn't a proper inclusion. Item 34, golf club membership. This went to the Court of Appeal. The Court of Appeal held that the evidence adduced was insufficient to establish an inclusion in respect of what type of membership privileges, the membership that was conferred on the family members, the nature and the cost of it, and the like. Now, in respect of deductions, that's the next heading. I'm going to quickly go through these items. I just want to point out that a very large subcategory within deductions is notional disposition costs. I presented a paper on this in December 02, and I attached that as Schedule B. I'm not going to talk about that today because Alfred Mamo is going to address it, and Alf has been charged with that particular responsibility because in and of itself it is a very significant area, as you can imagine. My paper at Schedule B deals with all the cases decided since Sengmuller, but it involves adducing very specific evidence, which Alf is going to get into. I'm running out of time, so I'll just point out to you that in respect of deductions, evidence is critical. And the court looks at real timing issues in respect of marriage date deductibility. When is that asset acquired? When does one develop an interest in it? And even something like a wedding ring. An engagement ring is a no-brainer. You can peg it as having received prior to the date of marriage, but in that tincture of time, when does one receive a wedding ring in the context of a marriage date deduction? Excuse me. Okay. Excuse me. There are a number of other cases which deal with this issue, both the timing issue and the quality of the evidence that's required in the context of proving a particular deduction. And those cases are set out. In respect of exclusions, and those cases starting at later on, before the schedule, I just wish to point out that there's been a lot of confusion in the context of calculating exclusions when it comes down to damage cases and pension cases, pensions that you get through the course of employment, disability pensions, and otherwise. And my review of the cases, and there's some contradictory case law on this point, but would seem to suggest the following: that any benefits paid for economic loss or reward during the marriage will be an inclusion because it constitutes property. If you get a benefit paid for something that occurred during the marriage for non-economic loss, such as general damages, for pain and suffering, and even the prejudgment interest on it, that's going to be excluded. And if you get any sort of benefit for future compensation, like post-marriage, post-separation, and it's unrelated to the pain and suffering, that's not going to be an exclusion. That's not going to be an exclusion. It's going to be income. So to sum up, evidence is key. Scrutinize that formula, please. Scrutinize the component parts. Scrutinize the evidence that you want to rely on, and try and focus on garnering that evidence from the moment the client first walks in, and ask yourself, what do I need to adduce to prove what I'm trying to prove? Any questions?
All right, we're going to run through our roll call again. Any questions in Barrie, please? Any questions in Brantford? In Hamilton.
The paid position.
It certainly is.
Yeah, it's okay.
In Kenora.
Oh, muffins and infractions. You forget there's...
Take a drink, too.
In Kingston.
Any questions here?
In Kirkland Lake.
No.
In London.
Would have helped the materials.
Anybody? No, guess not.
In Niagara on the Lake.
Like her owner with stuff.
In North Bay.
You're handing out the materials.
Hi guys in North Bay. In Ottawa.
Can we read this across the site since I gotta take
In Peterborough. Sault Ste. Marie.
Yes, just one question.
Yes.
On the last point, dealing with the, say, motor vehicle accident, an award for an income stream post-separation. And the last comments were that's not an inclusion, that's not an exclusion, that's an income stream. So the cases then you would suggest that this time you wouldn't include it or exclude it because it's not a capital, it's not property, it's simply income?
Again, it depends on the characterization by the judge. Clearly, if it's not related to damages, then you have to ask yourself, is it supposed to cover a period that is post-separation? Now, that would seem to be at odds with the case law dealing with income stream and coming up with a capital value on valuation date, but some of the case law that I've read would seem to suggest that if it's for something in the future, and it's related to a disability or an accident, you don't include it in the context of capitalizing it for NFP purposes. And these cases, I'm sorry, these cases, I'd love to tell you that there's a clear-cut case which deals with all these things. If you look at the exclusion cases that I have in the chart, you'll see some disparity and some between what judges say and some disagreements.
Any other questions in Sault Ste. Marie? Sudbury?
No.
Thunder Bay? Waterloo? Windsor? Toronto? I have a question, Robert. I've always wanted to be able to argue when I act for the, let's say, the wife in a second marriage, that when the husband came into that marriage, he had an obligation to his first family to pay support. And we all know how it grates spouses in second and subsequent marriages for a spouse to pay support to a previous family. I've always wanted to make the argument on behalf of, let's say, wife number 2, that when husband came into that marriage, he had an obligation to pay support to family number 1. And then based on the terms of that order or agreement that he had and the ages of his wife and children from marriage number 1, that was a debt or liability which should be taken into account in reducing his date of marriage net worth, even though it pushes him into a substantial negative, which we all know will increase his net family property. Have you ever seen a case where that's been argued successfully?
No, I haven't seen a case where that's been argued successfully, and I was thinking, well, is this a retroactive, sort of a retrospective determination? Suppose the husband had lost his job and he could vary support downward. Would that impact on the capital value to give out at the date of marriage for that particular item? I remember being in our office, you and me, you also tried to once argue that a husband's wrongful dismissal package that he got 2 years into the marriage should somehow be a marriage date deduction. And you asked me then, what do you think? And I say the same thing to you, forget it. I mean, there are a lot of vagaries of life, and you'd like to say retrospectively, had I known on marriage date that I'd be having this obligation on the other, shouldn't that have an impact? in the calculation of net family property, and in particular ascertaining whether there should be a marriage date deduction. Firstly, you have to make sure you're not talking about income issues, as I think you are when you're talking about support and one's obligation. Anyway, I could be wrong. The day could come where you're going to successfully argue that, but I've not seen any cases dealing with that issue.
I still think I'd get away with it, but we'll try. Question in Toronto.
Yeah, hi. Whoops. I have a question with respect to legal inclusions. If you're claiming a constructive trust, let's just say on a matrimonial home, there seems to be some conflict as to how you actually input on the financial statement. The financial statement talks about you putting legal ownership down, but if you're claiming a constructive trust just as an inclusion, right from the get-go, is it more prudent to put it down if you're representing the beneficial owner as part of the financial statement from the get-go as a beneficial interest, or do you leave it off of the financial statement because you know that the other spouse is going to be claiming it as a legal ownership, and then you deal with it after the fact?
Well, I think that you do both, and you put down a value as somebody claiming the beneficial interest, and you asterisk that value, say, pursuant to beneficial interest. Just make sure you're claiming that beneficial interest in the context of a rising market when you're acting for a spouse, because there was a time in the early 90s where you heard reverse constructive trust being thrown in somebody's face, saying, oh, I want to attribute to my wife, where the husband was the title person, the declining value of that property. So I would always insert it, because you're claiming an interest in it. The nature of the interest is something you can asterisk at the bottom of the page. I just want to make one more point in terms of what Lorne had raised about being these novel sort of arguments. I once acted on an appeal for a husband who at trial had asked that the wife's unused capital gains exemption be attributed to her as property, be her inclusion. I mean, you could go really far in terms of the benefits that are out there. I mean, I suppose on the date of marriage, the CPP benefit that I'd get on my death could be included. I mean, the point of the matter is that, sure, make novel arguments, but be mindful of the spirit and of the formula.
Unless there's any other questions in Toronto, I have one further question for Robert before we go to our coffee break, and that is, a day doesn't go by that I get people in my office who want to know whether money that was advanced by a parent is a loan or a gift. And typically, when I ask them and I say, well, was it a loan or a gift, they sort of glaze over and they say, well, what's better? And again, by then it's probably a little too late to recreate history, but we all know people have their own views. Robert, can you give us any type of guidance in terms of what's better, or how do we determine, because of course, whether it's a loan or gift determines whether or not you're potentially in a deduction situation or exclusion situation, and if it went into the matrimonial home, maybe it's nothing. Any suggestions how to deal with this problem?
This isn't staged. Lorne wrote an article, something like 50 Ways to Leave Your Lover, and in it he talks about the merits, even when everybody seems to be happy and the new marriage is starting and there's to be monies advanced from the parents. Give a mortgage, interest-free, if you're acting, or if you're a parent or you're acting for a parent. Suggest that, and hold it, register it on title, agree to rip it up at some point if the parties pass a certain time in their marriage or not, and never intend to perhaps collect on it, but register it on title. Otherwise, you get into that horrible conundrum you're talking about, and then before you know it, you're calling up a buddy who practices in another office in town saying, hey, do you mind acting for the parents of my client? They have to bring a claim against the daughter-in-law for the money. Try and avoid all that by getting a promissory note, or better yet, a mortgage in place prior to the date of marriage. If the kids don't want it, then, you know, I suppose you can give the money gratuitously, but you do so at your own peril.
Great, thank you. One last point. Most of you should know that the Limitations Act was amended in December, so the limitation period on a unsecured loan, say a demand promissory note, is now only 2 years. So what used to be good advice to parents in that situation, take a demand promissory note back, isn't very helpful anymore because that limitation period is going to run. So Robert's advice in terms of if you're going to protect yourself when you're advancing money to your kids, take a mortgage back is more important now than it ever was because those demand promissory notes are really of limited use. Okay. I believe it's 10 years if it's under seal, if I'm not mistaken, but I haven't looked closely at it, but I believe that's the case. But my point is the demand promissory note, and the case law says that the limitation period on a demand promissory note begins to run when the note is given, not when the demand is made. So in many of these cases, the limitation period is run by the time you want to take advantage of it. Okay, we're a little past our time. We're going to break to 11 o'clock. Go have a coffee. Try to be back in your seats so we can start promptly at 11. Thank you.